8,000 each. In default, to suffer simple imprisonment for 6 months. The impugned judgment dated so convicting the appellants is however not interfered with. The appeal is accordingly disposed.
Here the appeal is partly allowed. Section 302 has been converted to section 304 part 2. And accordingly, he is awarded with the sentence for 4 years life. 4 years.
Highly obliged.
Instead of
May I please, your lordship. Lordship, I beg to mention for listing of the criminal appeal 126 of 2016, lordship. This matter was listed on 3rd of October, lordship, but due to the bench did not sit on that day, lordship. Lordship, earlier you have,
Did not sit that day?
yeah, lordship, the bench did not sit on 3rd, lordship.
Oh, flight got cancelled. Oh,
Lordship.
okay. When do you want?
Tomorrow, lordship.
Tomorrow, this list is already there. Some other day.
Lordship, then the day after tomorrow, lordship. Grateful, lordship.
Is it a hearing matter?
That 313, there were 2 times it was recorded.
Oh, that matter.
That matter, lordship.
Okay, tomorrow. Tomorrow. doesn't
Tomorrow,
matter.
lordship.
Tomorrow. This is the matter.
Grateful, lordship.
Lordship, item number 3 is a legal aid matter, your lordship, and the present appeal has been filed against the judgment and order of the.
Okay, right. Third, Miss S. Sharma Hazarika, learned counsel for the appellant, who submits that the judgment dated 6/2/2023, by which the appellant has been convicted under section 302/324/325 IPC by the Sessions Judge Charadio in Sessions bracket CHA case number 5 of 2019 should be set aside. Admit the appeal, call for the LCR. Ms. S. Jahan appears for the state. This is the matter of the 4 weeks.
Obliged. 5 years is also already in fact. 8 years. It's time for 5 years.
So,
Nothing can be done.
My pleasure, lordship. I'm appearing as legal aid counsel, my lord. It's a jail appeal against a judgment and order dated 31.
Miss M. Burman, heard Miss M. Burman, learned, this is triple murder.
Yes, ma'am.
Heard Miss M. Burman, learned counsel for the appellant, who submits that the judgment dated 31/8/22 passed by the Court of Sessions Judge Baksa Mushalpur in Sessions case number 15/2019, by which the appellant has been convicted under section 302 IPC for triple murder
Consecutive sentence.
by giving consecutive sentences.
Right, Sylvan?
Should be set, comma should be set aside. Admit the appeal, call for the LCR.
My lord.
Ms. S. Jahan, additional PP appears for the state, list the matter after 4 weeks.
Okay.
Please, your lordship, this is a legal aid matter, lordship, the appellant was convicted under section 4 of.
Where is the impugned judgment?
Impugned judgment, lordship, he was convicted on the plea of guilty, lordship.
Where is the impugned
Impugned
judgment?
judgment, I
No,
have
no,
access
impugned
with the-
judgment with regard to the co-accused.
Lordship, in the 389 petition, lordship. IA number 975.
Mr. Counsel, there are three accused persons.
Yes, Lordship.
You have been convicted on your plea of guilt.
Yes, Lordship.
The other two persons have been acquitted.
Yes, Lordship.
Now, where is that order?
Order is Lordship in the IA number 975, annexure Lordship 3.
IA number? Yes. Yes, Mister. Give me the IA. Is the IA there? No, this is the criminal appeal.
975.
Okay. Where is the judgment?
Annexure 3, page 12, Lordship.
Yes, where does he say, where does the court say that no plea of guilt not recorded?
In the para.
Para 14, page 22.
Para 14.
From the record, it appears that no statement was recorded of the convict Sankar Pator on his plea of guilt. Correct.
Yes, sir.
What has happened is, this Sankar Pator was convicted on his plea of guilt. The others can claim trial. So there are two accused, the trial went on, and after trial, they were acquitted. But in the acquittal order, the judgment acquitting them, it has been stated that from the record, it appears that no statement was recorded of the convict Sankar Pator on his plea of guilt as required under 229. He should have been tried. Basically, what is saying that he could not have been convicted when there is no plea, when the plea was not recorded. So now he's saying that no, he did not make any plea. Now it has, so basically, it's because of the acquittal of the co-accused. Now he wants to be tried. Now. It seems to have a very good case.
Even the judge wrote that it was not recorded.
This is in the
Session
judgment.
judge.
Please show it to her. Please show it to her.
Because this was the-
Oh,
Para 14, the top side.
Sir.
you take this, take this.
Take it.
Para 14, the last portion.
That the records come, will be clear then whether that-
Correct. But then the thing is that, you see, it is a judgment of the trial court. Now, when the trial court itself has stated this,
Yes.
what more remains?
No statement of recorded of the convicted on his plea of guilt by the- So what was recorded and why it was the convicted?
No, in the order convicting him, she has, the court has said, that is in the appeal, and the order dated 17/7/2017. He has said that I have heard the learned PP and the learned defense counsel for the on the point of charge.
During the Sankar Pator was also participating, so that after the- And it is from the table to-
And also admitted before the court.
And also admitted that the committee might have been- Right, then no one will be able to do anything. They know, even also have- carry out the- And no one has stopped it from getting.
No, that's a different issue.
Yes.
But it was not even recorded in the order.
He had shown after this.
Perhaps, let us see the record.
Not at all.
Exercise, this is what it is last line of paragraph 10. In exercise of power under the implement of convict. Let me section 12. Thus the accused is convicted under one activity according to the punishment. Otherwise, this. And record is there, this. Recording of the.
Anyway, I do not know why the trial court has passed that order. Anyway, we'll see.
Statement, perhaps it's making a distinction between two statements.
No, you see, the thing is that there's a difference between making a statement and recording that statement.
That's
He-
the-
So probably he made the statement, but the trial court did not record it. So anyway, we'll see the record. That's all. One of the records that clarified the. Okay, right, heard, Mr.
B Haldar.
B.
Haldar.
Haldar, learned legal aid counsel, who submits that the order dated 17/7/2017 passed by the learned trial court in sessions case number 39 of 2017, by which the appellant has been convicted under section, has been convicted under section 120 capital B bracket /307/511 IPC, read with section 4 of the Explosive Substances Act, should be set aside in as much as no statement,
From the
Oh,
record.
no state, huh?
From the record. it's-
Anyway, in as much as no, his submission. In as much as no statement was made by the applicant, made by the appellant to that effect, and nothing has been recorded. As can be seen in para 14 of the judgment dated 27/6/2022, passed by the Sessions Judge Morigao in Sessions case number 39 of 2017, by which the two co-accused, namely Jiten Pator, JITN, Pator, and Motiram Diori, have been acquitted of the charges framed against them. Full stop. Next para. Admit the appeal. Call for the LCR. Ms. S. Jahan appears for the state. List the matter on when? Next week.
Records of- This one. Morika.
More than that, far. Because you see, he's been in jail for 6 years now. If it's
Or is arrogant.
probably,
Matter.
yes, he too arrogant. I'll continue to do this, that. Maybe okay.
I've seen in one matter, the statement of guilt needs to be recorded somewhere. It finds statement tablets.
Yeah. No, or it could have been recorded in the order sheet itself. Maybe it could have been recorded. So we'll have to see that. Only that is the, there's a format. There's a format where. Where in the CRPC is it there? Be sure. No, let us see.
Let's see what has been done.
It is guilty, when pleaded guilty, that must be there in the order sheet. Pleaded guilty.
It should have been in the order sheet.
That order sheet is not. there.
Or order sheet or in the framing of charge.
Yes,
That form, in that form. So there are two things. One is it can be done in that framing of charge ka form. Or it can be done in the order sheet. Now we'll have to see these two aspects. No, format, what he's talking about, I'm quite sure is that format where the charges are framed. That's the only, there will not be any separate. So it will be either there or in the order sheet. Okay, right. This is a matter when after puja, no.
Maybe after puja, otherwise, yes.
This is the matter. List the matter on 6/11. 6/11. And then you write, we would have to see whether the appellant had made any admission regarding his plea of guilt under section 229 CRPC, either in the order sheet of the learned trial court or in the inverted commas form used for framing of charge used by the learned trial.
But if there is an IA for bail, Lord.
Right, Ms. S. Dahan is granted 3 weeks time to file written objection to the application under section 389 CRPC. He has to be given that opportunity.
It can be disposed of on the day itself.
Otherwise, we can dismiss this IA now. There's no point keeping it pending. We'll dismiss the IA.
Yes.
Right.
Right.
Right,
Right.
right. This is the heard
may-
Mr. Sensor Council for the applicant who submits that this is an application under section 389 CRPC for suspending the impugned order dated order dated 17/7/2017, passed by the learned, Sessions Judge Morigaon in Sessions Case number 39/2017, by which the applicant slash appellant has been convicted and sentenced under section 120B/307/511, read with section 4 of the Explosive Substances Act. 511 IPC, read with section 4. On his plea of guilt. Full stop. He also submits that the applicant Sankar Pator has been punished to undergo rigorous imprisonment for a term of 10 years with a fine of rupees 25,000, in default, rigorous imprisonment for 1 year under section 120B IPC. He has also been punished to undergo rigorous imprisonment for 10 years with a fine of rupees 25,000, in default, to suffer rigorous imprisonment for 1 year under section 307 IPC. Further, the applicant has also been punished to undergo rigorous imprisonment for life with a fine of rupees 50,000, in default, to undergo a rigorous imprisonment for 2 years under section 4 of the Explosive Substances Act, 1908. Then you're right. And the same thing which we had put in the appeal, we put that. Then you're right. Ms. S. Dahan, the learned additional PP submits that the only issue that has to be determined by this court is with regard to whether the applicant and whether the applicant's statement regarding his plea of guilt was recorded by the learned trial court under section 229 CRPC. Full stop. No. Explosive is there in life. Full stop. As such, the same would be clear on perusal of the lower court report. Full stop. She accordingly submits that the present application may be dismissed as the only issue that as the issue to be decided would become clear once the lower court reports are made available with this court. Full stop. On considering the submission made by the learned counsels for the parties, we are also of the view that the present appeal is to be decided only within, was to be decided within a very narrow compass, that is with regard to whether the statement of the applicant Sankar Pator regarding his plea of guilt was recorded under section 229 CRPC, on the basis of which he has been convicted by the impugned order dated 17/7/2000, whatever it is, huh? 17/7, so, pass it, so, accordingly, at this stage, we do not find any reason to allow the applicant's application for suspending the sentence and allowing him to go on bail. The application is accordingly rejected. Okay, right. Heard, Mr.
Ayu Chaudhary, Lord.
Ayu Chaudhary. Your name is not here.
Lordship, Mr. A. Ahmed, my name is not there, Lordship. He is on that. Lordship.
Okay, heard Mr. A. Ahmed, learned counsel for the appellant, who submits that the impugned judgment dated
5/8/23.
5/8/23 passed by the special judge bracket POXO, Karbiang Law, Difu, in POXO case number 23/2022, by which the appellant has been convicted under section 6 of the POXO Act should be set aside. Admit the appeal. Call for the LCR. Then what to do about who is R2? R2 is the father,
No, Lordship. Brother, Lordship.
Huh?
Brother of the victim, Lordship.
brother of the victim. He's the informant.
Lordship.
The additional PP S Jahan shall submits that she will send the copy of the appeal to the concerned officer in charge of the which police station?
Bukajan, Lordship.
Of the
Bukajan.
Bokajan police station. For for delivery, no, what have I said, just read? Who shall deliver the same to the respondent number 2. In terms of the order dated 23/6/2023 passed in the case of Deepak Nayak versus State of Assam, criminal appeal bracket J 40/2022. To enable the additional PP to take steps as indicated above, the appellant shall serve a copy of the, shall submit a copy of the appeal to the registry, who shall in turn furnish the same to the additional PP Mrs. Jahan. Stop. Next para, you're right. The additional PP shall thereafter submit a report with regard to delivery of the copy of the appeal by the OC of the so-and-so police station. This is the matter after 4.
Lordship, IA is there, Lord.
Huh?
IA is there, Lord.
You're right, Ms. S. Jahan, additional PP is granted. 3 weeks time to file a written objection to the application under section 389.
Abla. May I please, your lordship? Lordship, I am appearing as an amicus, my lord. Paper book received, my lord. Matter ready for hearing, my lord.
Okay, right, Miss A. Tiwari, learned amicus curiae, and Miss S. Jahan, additional PP, submit that they have received copies of the paper book. Full stop. Accordingly, this is matter for hearing in usual courts.
Deeply obliged, your lordship.
Right, Miss S. Jahan, additional PP appears. No one, before that, right, no one appears for the appellant. As paper book has been made, has it been given to you?
Perhaps it's there, but,
Paper book served upon additional PP with S. Jahan.
to our office must have signed.
So. Okay, right. Office note dated 4/10/23 indicates that paper book has been served upon the additional PP Miss S. Jahan. It also, the office note also indicates that paper book has been received by W.R. Medi, learned counsel.
Thank you, apology, my lord.
You have received the paper book?
Yes, yes.
Received,
Due to
okay.
traffic congestion.
By, just say Mr. W.R. Medi also submits that he has received a copy of the paper. Accordingly, this is matter for hearing in usual courts. What about the IA?
Find my objection, I remember, no, I've given it that, need to be.
No, you have
Oh,
filed, you
yes,
have
yes.
filed.
Yes,
Yes, yes, yes, yes, it is, yes.
Mail. If you want to look at it, yeah.
Yes, you can hear it. Everyone, the IA.
My lord, this IA has been. It has been filed because of the, for granting of bail in this criminal appeal. That has arise out of the judgment and order dated 18/8/2022 passed by the learned session judge.
Just a minute, my pen is not working. Yes, pen is not working, this red one. Pen is not working. Give me a red one. Judgment order dated
18/8/2022 that has been passed by the learned session judge Majuli.
18/8, and the incident occurred when?
16/6.
Okay.
2018, my lord.
16/6/2018.
My lord.
Okay, then. 302, correct?
Yes, yes. Now, already he has been during the filing of this petition, he has
5 years. Was he on bail
no, my lord.
before the learned lower court?
No, directly he has been sentenced to jail. From the conviction. During the trial time, he was in bail and then,
That's what I'm saying.
yes, 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 yes. From there, he has been sent to.
So he has been, okay, yes, so why should the sentence be suspended?
My lord, the main ground here is that in the IA, the evidence that has been deposed by the prosecution witnesses are mainly from the extrajudicial confession that has been made by the accused.
By the accused?
Yes, yes, he has made the confession, but the honorable trial judge had failed to appreciate the evidence in the manner that should have been done. Because of the fact that in the majority of the witnesses that has been examined in the case were interested witnesses, ma'am.
Interested in?
Yes, ma'am. And very few independent witnesses were there. And in also in the cross examinations, many contradictions had been seen, my lord, from the side of the prosecution. And my lord, now since he has already spanned from the date of his judgment from 18/8/2022,
Yes, 1 year.
one and almost 1 year, 5 months
But how come 1 year, 5 months?
is 18/8/2022. So now we are in almost 1 year, 4 months, 3 months, my.
How 3 months?
Already October, we are in the October, so 1 year, 2 months. my.
Not even 1 year, 2 months. Anyway,
Yes.
that's all. One life gone.
My lord, the fact is that the age of the petitioner is also to be considered.
How much is the age?
The appellant, my lord, his age is 65 years. He's he's a senior citizen, my lord. So, my lord, in the appeal, we have taken some grounds.
So what are the grounds?
Basically, except the case number 9 is the main appeal, my lord.
Paper book you mean? Or the appeal?
No, in my
Appeal.
appeal.
Page 9.
Since paper book has been provided to me on yesterday only, so that is why I've also not done. So that is in the ground number. That is paragraph number 10. The ground is D, page number 9.
Yeah.
D. Here we can see that except the investigation officer and the medical officer appearing to there, all the other witnesses appears to be like interested witnesses. Only two
So?
independent witnesses were there.
So why should we disbelieve the interested witnesses?
No, my lord, during the pendency of the appeal, only the fact that we are now for IA is for the bail, considering his age and his seniority.
But bail is not, automatic.
Yes.
You must give some grounds why we should be granted bail.
My lord, basically, since already it has been submitted that the judicial confession which was arrived at could have been procured through coercion and threat also, my lord. Since it is a weak piece of evidence, since it has been given in before the investigation officer, the police. So no, it will be before the police 161. Oh, 161. The 161 statement.
Yes.
Evidences are very less. What I can do, that is not the 164.
The 161. Yeah. Yeah.
Only I think that he went to the Bhavna, 2 o'clock in the.
What is the Pauna?
It's a kind of a
Dra-
play,
Concert.
theater,
Yeah, theater.
Theatre drama.
drama. And then he was not found.
He was looking for his bike.
And of course, that there is not the, but fact is there was enemy there.
Yes, my
There was some land dispute. And he was involved in arresting of infant stature.
Oh no, he beat up some infant starter the night before.
The accused people. So perhaps the accused.
Not the accused himself, the deceased.
assaulted one as an infant snatcher. And perhaps because of that, there was some enmity and all. But pointing to these accused, evidences are very less. PW2. He heard you had tried, but then he saw only the body and it was.
There are some hostile witnesses.
Yes, my lord. That PW4, there is Konpona Hazorika, who was declared as a hostile witness in this.
5 also.
5, PW5, my lord, yes, my lord. 12 and 14 also.
5 is the person who said that 5 is the son of the appellant
Yes, my. He
who
was,
saw his father killing
yes,
the
my.
deceased.
Yes, my lord.
but then he resigned.
Yes.
Should be. He saw his father hitting the deceased in the pond.
It was the time of the incident was quite early in the morning. So there was the light, the sunlight, the uh, light was also not clear at that time because in the pond when he saw
Page 18 of the. Wait, not this one, not PW. Then PW 5 is the father of the deceased. Huh? Then there's another, sorry, there's another one. Anyway, what was this appellant, the deceased doing at 2 o'clock in the morning, but without his bike? He's looking for his bike.
Yeah. Deceased.
Yes,
On the bike. And he did not find it. And when he started, so yeah.
They're not very many. What is there in the 313?
two defense witnesses are there. Or he had also produced.
Huh?
That was 161.
The thing is, there's hardly any evidence.
Everyone has done hostile. I don't see any positive statement written in hostile part.
There's a lot of gaps.
Yeah, mine.
Oh, yeah, it appears. Oh, so, okay, so, sentence suspended, bail allowed. For how much bail? What? Huh? 20. Order will come out later. It takes some time.
Yes. Oblige you.
So I think R2 has been served in terms of the CGM's note. Notice on R2 has been served. Right. In terms of the letter dated 26/9/23 issued by the CGM Nagaon. Service of notice is complete. Again, there is point number 2. Full stop. As LCR has arrived, registry to prepare the paper book. This is the matter of the poll.
Office note 31023 में kind.
Huh?
Office note 31020.
Yes. Yes. So you tell me, this is with regard to section 4. There is a W already filed. Now you tell us why this sentence should be suspended.
Now, my lord, on the basis of even my lord, on the basis of a Xerox copy of his transfer certificate, my.
Huh?
On the basis of a Xerox copy of transfer certificate, my.
Xerox copy
Of a transfer certificate, my.
of transfer certificate, yes.
So proceed, he was convicted under POXO, my.
Huh?
The appellant was convicted under POXO, my.
Convicted under POXO.
My.
huh.
Now, my lord,
According to you, what should be what is the age of the victim?
my lord, as per medical evidence, she is 18 to 19 years, my lord. And even my lord, office note, your lordship will see the trial court, my lord, 16/12/20, the addition, the public prosecutor.
Case number 327/17, new. And session case number 33/2010.
No, let us go
Oh,
straight to the.
Yes, FIR.
FIR. Huh.
My lord will kindly come to page 3, my lord.
We'll dispose of the entire thing.
Yes, my lord. Entire,
Why?
entire.
It's the same thing. See, his basic case will be that the father pushed the son. Correct?
Not that, that is the prosecution's case and that is the 164 statement of mine.
The father pushed the son.
Yes,
And if the father pushed the son, and the son hit his head,
yes,
isn't that the case?
yes, my lord.
There was no weapon used,
No, no weapon used,
so it was a case of pushing
pushing,
and head injury.
head injury.
So it appears that maybe 307 could come in.
But 304,
4-2, part 2,
Provided we delete this content.
or 304A.
yes, my lord.
I don't.
But that would be, my lord, if this 164 statement holds, my lord. If the
Okay, you
164
have got a 164 statement.
Yes, my lord. If the 164 doesn't holds, my lord, then the situation will be different. my lord. Because 164 statement, it is before my lord today. Whether London Trial Court has been able to administer or has been able to examine whether 164 statement, the provisions under 164 has been complied or not. But the law is well settled, my lord. My lord's judgment is also there, my lord. My lord, before that, my lord, retracted, my lord, retracted also. No, no. I will submit, my lord.
No, he's trying to say that all the guidelines are followed.
Not followed. But page 3, my lord, of the
No, let
paper.
us go to the, yes, to the FIR,
Of the FIR,
page 3.
page 3, my lord. That is dated
FIR dated
22/8/2004, my lord.
2284, yes.
Informant, my lord, will kindly say Prahlad Kemprai, my lord. He is the PW 12, my lord. Sir, may I read, my lord? With due respect, I would like to inform you that at 11 AM on so and so, when I received the news that my nephew so and so, Nipen Borwa, age about 5 years, 5 months, had gone missing.
Nephew meaning through the mother.
Yes, my lord, through the
Mother.
mother, through the mother. Age 5 years and 5 months had gone missing. I, along with some person, made extensive search for him, but could not trace him out. Later, I came to know that at 11 PM, my brother-in-law, Nipen Borwa, recovered the dead body of my nephew, Chanakya Bora, from the septic tank located in the campus of the government quarter where he lived. The boy by the name of Binod Mirza, who stays as domestic help in the house of my brother-in-law, Nipen Borwa, said that Nipen Borwa has committed the murder and my brother-in-law to confess that he had killed his son. Therefore, I request to take necessary action in this regard. Thereafter, my lord, will kindly come to page number 6, my lord.
No, let us, yes, page 6.
Page 6, the charges were framed initially under 302, my lord. Then at page 7, my lord, the charges were altered and 302 along with 201 was added, my lord. on 16 September 2022. Thereafter, my lord, because my lord, in the FIR, the
So what is wrong? 302,201 is not right. You
yes, my lord.
hiding evidence.
No, I'm not disputing, my lord, but initially it was 302, then 201 was added.
Then
Then, my lord, may I take, my lord, first to, my lord, a statement of Vinod Mirda, my lord, 127, my lord, page. That is, my lord, before the police, my lord,
how many prosecution witnesses?
11, my lord. But number 8 is not there. So 7 directly 9. So it is numbered as 12,
10.
but numbered as
11.
12, but
Okay.
11 it is. Twice. 8 to 9 আপনার। No. আপনার 8 to 9. দুটা করে দিতে, but 11
No. In this paper book, there are 311. Two are same. Altogether 12 witnesses. Correct.
if you calculate my lord 11 as my lord twice, then it will be.
Actually, you have to calculate.
Yes, my lord.
Just
But
because
same
they-
witness, my lord, but not is it is not a
They are
different.
not same witness. One is Dr. Narendra Nath Rajkhowa and one is SI Sankar Banerjee. They are different.
No, my lord, PW
Have you
11.
got the paper book with you?
Yes, my lord.
Now, please look at the index of the paper. book.
Yes, my lord. Yes, my lord. I'm sorry, my lord. My lord, may I take first to my lord to 127, my lord, page number 127. Page number 127, my lord. He also happens to be the PW1, my lord. Before I take to his his,
This is 161.
yes, my lord. It is an extrajudicial confession, my lord, taken. My lord, may I read, my
It's a
lord?
judicial confession of whom?
Vinod Mirza, my lord.
Vinod Mirza, is he an accused?
No, my
Appellant? Then how can it be a confession?
It is a confession, my lord.
What is he? What has he got to do? What has he got to confess?
My lord, he was taken to the police custody and he was asked to, my lord, give statement against the accused person, my lord.
So can that be a confession? What do you understand by the word confession?
My lord, because
A
this,
confession is when you inculpate yourself.
yes, my lord. I'm sorry, my lord, it is statement of Vinod Mirza.
Then say that
Yes.
this is not a confession.
Yes, my lord. Statement of Vinod Mirza, my lord. I'm sorry, my lord. Then, my lord,
Statement under 161.
yes, my lord.
Don't use words just because you have heard the word,
Yes, my lord, I'm sorry.
unless you're putting it in some context,
Yes.
proper context.
My lord, will kindly see at page 127, my lord.
Yes,
Vinod Mirza, my lord. Age is 14 years, my lord. Father's name so and so. My address is so and so.
just a minute, let us turn our pages. Yes,
My name is Vinod Mirza, my lord. Has my lord got it, my lord.
yes.
Age is 14 years, my lord. I know Nipen Borua. I used to stay in his house near Dairy Farm, Manja, as his help, and also to study. I am from Golaghat. Originally, I have stayed in Nipen Borua's house for about 2 weeks. Nipen Borua's son wanted a pencil box. For that, he was pestering the father. The son on 21/8 again troubled the father for a box. The father slapped the boy. At this, after that, he again beat the boy on the chest and pushed him near the steps. The boy got hurt and became senseless. The father sprinkled water on the boy's face. When the boy did not wake up, the father must have been scared. He picked the boy, opened the lid of the tank of the latrine. He threw the body of the boy in the latrine tank and closed the lid. I was watching it all from the window inside. When he saw me watching, he told me not to tell anyone and warned me that he would send me up there if I told about what I saw. That time the boy mother was in the office. When the mother came and when it was late, both went in search of the boy. I did not tell anything as I was scared. Then police took me to Thana and beat me. Then I whatever I saw and knew. So this my lord will make a note, my lord, 23/8/2004, my lord. 23/8/2004. On the so thereafter, my lord, may I take my lord to his deposition at page 10, my lord. Page 10.
Page 10.
Page 10,
Yes.
my lord. He is PW1, my lord. This is on 16th of November 2013. My name is Bindu Mirda. And may I read, my lord? I do not know the informant. I know the accused. I also knew the deceased. The incident took place in 2004. At the time of the incident, I was in the house of my aunt, here, mother's younger sister, which is situated beside the house of the accused. On the day of the incident, the dead body of Chanakya Bora was recovered from the septic tank of the accused person's house. On hearing commotion raised by the people, I came to the house of the accused person and saw the dead body of the deceased. I know nothing else about the incident. In the cross, my lord, I did not witness as to who had killed the deceased. So why I had taken this honorable court to the statement first, then to the deposition of this witness, because my lord, in the FIR, it seems, my lord, it appears, my lord, that the informant came to know that this Binod Mirda has seen the incident. So Binod Mirda himself, my lord, denied it. Thereafter, my lord, not a single witness, my lord, saw or admitted to seeing the what incident has what as regards the incident, my lord. Thereafter, my lord, may I take, my lord, directly to extrajudicial confession of the accused person in the police station, exhibit 118, my lord. 118, page number 118, my lord.
What do you mean extrajudicial confession? Extrajudicial confession of whom?
Of the accused, my lord. Lord, it is written as if in the paperwork, from the paperwork itself, I am reading, my lord.
So don't believe everything you see.
Yes, my lord. My lord,
No, then it is signed by, it is before the police or what is it?
it is before the police, my lord.
And this is 161 statement.
Yes, my lord. But because in the paperwork, that is why I am submitting, my lord. Otherwise, my lord,
Mr. Counsel. You see,
I am sorry, my lord.
you see. Now, it will be very easy for you to lead us up the wrong garden path
No, my lord.
unless you're clear on the subject.
Yes.
You see, you have got a duty to lead us on the right path.
Yes.
If you read everything what they say, then what's the point of this court being here?
Yes, my lord. I'm sorry, my lord.
Huh? You have got to ensure that what you say before this court is the correct thing, the correct law. Just because something is written there by the police, it doesn't mean that's the gospel truth, is it?
Yes.
And otherwise, what is the point of you of filing this appeal before us?
Yes, my lord. My lord, at page 180, my lord. This is a statement of the accused before the police, my lord.
Under which section?
161, my lord.
Okay.
May I read, my lord? Today, that is on 23/8/2004, Sri so-and-so, son of so-and-so had made confession in front of IC Manjav outpost over matter of killing his own son in presence of the below signed witness in the following manner. At 12 noon on 21/8/2004, while my son Chanakya Bora was disturbing me, I, Sri Nipen Bora, got angry and pushed him with his hands, as a result of which he fell on the steps leading to the toilet, sustained injuries and became senseless. This made me lose my mental balance and I put him inside a septic tank. Thereafter went hither and thither like a madman, searching for my son. At last, I informed the police station that my son had gone missing. At around 11 p.m., being unable to control my mind, I opened the septic tank and took out the body of my son. I think that my son had died as a result of sustaining injury, and I had put him inside a tank in order to save myself from the law, thereby killing him eventually. I make this confession in sound mind. So, my lord will kindly again note, my lord, that date is 23/8/2004. Why I am pointing out the dates, my lord, because at page 137, if I may take, my lord, too, this is the 164 statement, my lord. Page 137. Page 137, it starts, my lord. 164 statement. And my lord will kindly see at page 138 in the upper side, my lord, on the right hand side. Point number 1, the accused Nipen Borua is brought by police sub-inspector before court. Thereafter, my lord will kindly come to page 148. What were the questions asked to him? Page 148. Question on the right hand side of my lord of 148.
Yeah,
And answer any further statement made by the accused. I am a magistrate.
148.
Page 148, my lord.
Approach room for cattle.
Oh,
and
page
farm.
143, my lord. I'm sorry, page 143. Actually, this is not discernible from my paper book.
Yes,
Page 143, my lord, right hand side.
yeah.
Questions, my lord. I am a magistrate, was put to the accused, my lord. I am a magistrate, not a police officer. Yes, I understand. You are not bound to make a confession. I understand. Your confession will be used as evidence against you. Yes, I understand. You will speak the truth. I will. So these are the only questions which has been asked to him. Thereafter, my lord, at page 144. At page 144, the statement was recorded. At last paragraph, my lord. Tanekya was my son, about 6 years old. On 21/8/2004, I brought him from school at 11 a.m. He was pestering me for a pencil box. I pushed him in anger and his head touched the steps. Blood came out and he became senseless. I became very frightened and I did not know what to do. In fear of being caught and its consequences, I threw the body of my son in the latrine tank. I did not tell anyone about it. Everyone went searching for the boy. I felt guilty and restless. Later, I myself took out the body from the tank. Then I confessed before the people of my colony that I killed my son. Actually, I did not mean to kill him. Who will kill one's own son? It was an accident. I became mad then. I do not know why I later threw him in the latrine tank. So my lord will kindly see, this was also done on 23/8/2004. 23/8/2004. Point I'm trying to make before this honorable court is that under 164 statement, my lord, the law as regards the point that reflection time, my lord.
No reflection time.
Yes, no reflection time. Sarwan Singh judgment, my lord, says that 24 hours reasonable time should have been given. But it is different. Later on, Supreme Court says that in Sankaria judgment that no, Sarwan Singh judgment was on a different footing. He was taken from directly from different place. So police custody and judicial custody. So my submission before this honorable court is that moment he was taken confession by the police, he was taken for this 164 statement. And even the magistrate, my lord, has in his cross has admitted that 3 hours reflection time was only given. And my lord will also note one fact that
3 hours given out here. in
3
this
years
case.
given, 3 hours time.
So 3 hours good enough.
And my lord, one more thing, my lord will appreciate in this 164 statement that under 164(4), my lord, once the statement is recorded, my lord, after that, my lord, the magistrate needs to give a certificate to that effect at the foot of the memorandum. If that certificate is not given, my lord, the law says that it is the 164 is not, my lord, admissible, my lord. So in this case, my lord, after the statement was taken, my lord, 164(4) was not complied, my lord. And my lord is also aware, my lord, that assurance has to be given that he will not again send back the police custody as has been held by our division bench, my lord. And recently, my lord has also relied upon the judgment in one of the judgment authored by my lord. So my respectful prayer before this honorable court is that 164 has not been complied with. And in this regard, my lord, First of all, my lord, I would like to rely upon 2011 2 SSC.
Page,
Page, my lord. Paragraph, my lord, at page, my lord, at 521. Paragraph 64.
it starts at 490.
Yes, my lord, it starts at 490.
So you want para?
Para 64, my lord.
Yes,
Para 64.
yes,
My lord, the following principle emerged from with regard to the section 164 CRPC. The provision of section 164 CRPC must be complied with not only in form but in essence. Number one. Number two, before proceeding to record the confessional statement, a searching inquiry must be made from the accused as to the custody from which he was produced, and from the to the custody from which he was produced, and the treatment he had been receiving in such custody, in order to ensure that there is no scope for doubt of any sort of extraneous influence proceeding from a source interested in the prosecution. Number three, magistrate should ask the accused as to why he wants to make a statement which surely shall go against his interest in the trial. The maker should be granted sufficient time for reflection. And number five, he should be assured of protection from any sort of apprehended torture or pressure from the police in case he declines to make a confessional statement. Number six, a judicial confession not given voluntary is unreliable, and more so when such confession is retracted. The conviction cannot be based on such retracted judicial confession. And in this case also, my lord, and under 313, he has retracted me. Number seven, non-compliance with 164 goes to the root of the magistrate's jurisdiction to record the confession and renders the confession unworthy of credence. Then there are, my lord, number 8, number 9, and till number 11. So, my lord is already aware of these judgments, my lord. And my lord, this is, my lord, time for reflection, Sarwan Singh's judgment, my lord. 24 hours, although it has been
para?
probably I have given my copy also.
Huh?
I have given my copy also. Sorry for. My lord, will kindly come to page number, my lord, 12, my lord. Page number 12.
Yes,
I have no trouble, my lord, only the relevant last of the paragraphs, my lord, at page 12, my lord.
yes,
However, speaking generally, it would be think.
24 hours.
Yeah, 24 hours. So, my lord, then, my lord, I would be relying upon a judgment of the, my lord.
How many judgments have you got?
Yes, my lord,
No, don't give the normal run of the mill judgment.
yes, my lord. Well, this is regarding, my lord, 164(4) has to be complied, my lord. This is of the Madras High Court, my lord. Page, para 11, my lord, and para 11, my lord. Para 11 and 12, my lord. And relevant, my lord, I will read para 12, my lord. A reading of subclause 4 of 164 CRPC as interpreted in various decisions, we are of the view the magistrate, while recording confession under 164 CRPC, must follow the procedural formalities and ensure that all the requirement of provisions are complied with properly. In as much as the certificate memorandum as one required under 164(4) CRPC is mandatory, We are of the opinion that the learned magistrate PW 9 has not strictly followed all the requirements of the provision contemplated in order to ensure that a confession statement given by the accused was voluntary in nature. Accordingly, the document exhibit P6 falls short of judicial confession as contemplated under 164(4). In such circumstances, it has no legal significance in the light of law. As said earlier, two certain recoveries were made. It is not in dispute the root cause of same for the same is a statement of A4 to PW8 and PW9. In view of our conclusion, the information is pointed out above, it would be unsafe to sustain the conviction. So 164(4) is mandatory, my lord. Right. And there is one more, Lord, one era 1978 Supreme Court, my lord, regarding 164(4) only, my lord. Paragraph 29.
Yes,
Paragraph 29, my lord. Only the relevant portion I will read out, my lord.
yes,
Paragraph 29, my lord. From the bottom, my lord, 1, 2, 3, 4, 5, 6, 7. Seventh line, my lord, from bottom.
yes,
But it starts with but, my lord.
but the law does.
But the law does preemptively require that after recording the confession, the accused, the magistrate must append at the foot of the record is memorandum certifying that he believes that confession was voluntarily made. The reason for requiring compliance with this mandatory requirement, the close of the recording of the confession appears to be that it is only after hearing the confession and observing the demeanor of the person making it that the magistrate is in best position to append the requisite memorandum certifying the voluntariness of the confession made before him. If the magistrate recording confession of the accused person produced before him in the course of the police investigation does not on the face of the record certify in clear categorical terms his satisfaction or belief as to the voluntary nature of confession recorded by him, nor testify orally as to.
The same would be fatal if it's
Yes,
not done.
yes.
That's what defense.
Yes, my lord. And regarding, my lord, this our division bench order, my lord, that, my lord, assurance has to be given after the confession was taken that he won't be sent to the police custody. This is paragraph, my lord, 29, 30, and 31. 32. I will read only the relevant paragraph, my lord. 32 and 33. As my lord is already aware of the rule.
Para?
Para, my lord, 29, 30, 31, 32, 33, my lord, and 34. 32 and 33 are relevant, my lord. I will read out this, my lord.
Yes,
Carefully perusing the said caution recorded in the form of recording confessional statement, we find that the appellant was not sufficiently assured. In the event of refusal to make confessional statement, he would not be given to the police custody again. Therefore, in our considered opinion, the appellant did not get assurance for the court that he was free to confess his guilt, if any voluntary, without having any fear of going back to the police custody. Para 33. In absence of any assurance in this regard, it cannot be concluded that the appellant was free from fear of being sent to the custody of police again. In our considered opinion, the said evidence in a manner which the confession recorded would have inspired confidence to believe that the said confession statement was freely, voluntarily, without any influence or threat.
look, how many judgments? I think that's enough.
Yes, my lord.
for this.
So on the 164, my lord, these are the judgments only I am relying upon, my lord. So what I want to point out before this honorable and submit before this honorable court is that all these requirements are not being fulfilled. And 164 was recorded, my lord, summarily, my lord. And because of which, my lord, the entire conviction was based on, my lord, 164. So if the 164 goes, my lord, the conviction also goes, my lord. And, my lord, regarding, my lord, whether 164 statement, my lord, assuming, my lord, that 164 is correct or is assuming to be correct, my lord. Then also, my lord, this would be case under, my lord, 304A, rash and negligent act causing death, my lord. Why, my lord? Because why would a father, my lord, caused the death of his own son. It was only because, my lord, he was pestering for it. If I take the, my lord, 164 statement on the face, my lord, on the face of it, my lord, he was pestering for a pencil box. He just pushed him, my lord. He pushed him, and the son got a fracture in the skull, my lord.
Can there be a conviction on the basis of a statement made under 164?
My lord, it has to be, my lord, corroborated, my lord.
There is one Supreme Court judgment I had, Kohli versus State of Karnataka, where it was said, confession can be the sole basis of conviction, provided it was voluntary. That has to be voluntary.
Anyway, in this matter, in this case, where's the intention to commit a crime?
Yes, my lord.
And moreover, this is the case where the judiciary was not practiced. So the strict compliance of the guidelines would not be required, as held in Rapan Singh's case by.
No, but in any event, where is the intention to commit a murder?
That is, of course, that is a different issue. As far as not following the guidelines
What guideline?
of confessional statement, voluntariness or all those certificate and input of the confession, those are, I think, mandatory. But those are not followed, but since this is a case where it has taken place in Karnataka, where judiciary is not separated, following Rapan Singh's case, back 1967, PRTC has to be followed in spirit. So certain things are not followed strictly. But
No,
that will not.
I've been assuming that it's not followed, assuming, not agreeing to it, assuming it's not followed strictly. But where's the ingredients of 302 made out? Not there at all.
And subsequent judgment Supreme Court said.
And he's been in jail for how long?
My lord, once this order of
He's on bail.
he's not on bail, my lord. On 30/11/2022, my lord, judgment was pronounced. Thereafter, my lord, he is behind the bars only.
It's reflected also reflected. How long he is like. I'll check.
On 30/11, my lord, the judgment was pronounced. Thereafter, he was thereafter.
Yes, yes, we have heard you.
Yes.
Yes, but
Yes, and a subsequent Supreme Court judgment said that retracted confession requires some corroboration.
So-
But here corroboration, I don't get.
here there's no corroboration, nothing is required.
At all.
In fact, there's no case made out for 302. Maybe it's actually unfortunate incident, basically. It does not even come under provision. It's just a simple, it's what do you call it? Some incident occurred, unfortunate. That's doesn't appear to be. Yeah. Putting the septic tank was bad move. Very bad move.
I got scared. He only had showed. And he also had said how the body, I think, he
What is the injury report?
head injury.
Head injury, that's all.
Yes, my lord, head injury.
So head injury because he hit his head on the head, whatever. But that. I mean,
Otherwise, legally, if we see that we are left with only confessional statement, it's not corroborated. It is retracted. So, in a way, and there are violations of competence, not because of this. Only
without going into 164 itself. I mean, the sequence of events and whatever is there does not show any mens rea with regard to 302. I'm not even sure if 304 can come in.
Yeah, no, my lord.
I don't know.
My lord,
Correct. Because of the pencil.
Well, may I rely upon a judgment of 304A? Why should it should come in and why not 229 and
No. Why do you want to?
Yes.
Why do you want to go only on that?
Yes.
Judgment. The facts in itself should speak for it.
Yes.
The facts should speak for itself.
Number 323 then, not if immediate or without it being listed.
323. Might come under 323 or maybe 304A also. Anyway, okay, I think we have heard.
As the body was found, it's do not say how they recovered the body.
No, he opened the
Safety.
he opened the septic tank and he took it out, fished it out. His guilty conscience couldn't hold out any longer. That is the only thing.
Mother has filed the IA. They have performed this.
No, that's a different issue. There was no intention, there's nowhere. Only thing is that kid is pestering you for a pencil box. Probably they are poor people also got annoyed, pushed. Unfortunately, resulted in his death. Then nothing,
How long is inside?
whatever it may be, how does it matter? He said that since 2011.
no, my lord.
Huh?
He has been inside since this judgment was pronounced by
When
the
was the judgment?
30/11/2022.
39/22. Okay, it's enough. Acha, only then.
Yes,
Before that, he was not
The
there.
trial
perhaps he was inside, my lord,
Let us
for
see,
3
let us-
months.
Yes. 30/11. So we'll see how it is.
Well, during the trial, 3 months, 10 days. If my lord,
Give-
take-
Thirty, 11, 22 means he's been there for around 10 months. And the lower court,
my lord, if my lord sees in the paper, my lord, at page 81, 3 months, 10 days, my lord. During the trial.
file.
81,
Page 81.
date of arrest, date of bail. Okay, date of arrest is 23/8. 2004. 3/12/2004. Three months, and how many days?
3 months, 10 days, my lord.
3 months, 10 days. So he's been in jail for around 1 year.
Yes.
Okay, right, heard, Mr.
NDP Sinha, my lord.
Learned counsel for the appellant. Also heard Miss S. Jahan, additional PP for the state. This appeal has been filed against the impugned judgment dated 30/11/22, passed by the Sessions Judge, Karbi Anglong, Diffu, in Sessions Case number 327/2017, bracket new, Sessions Case number 33/2010, bracket old, by which the appellant has been convicted under section 302 IPC and sentence no, and 201 IPC. First time. The appellant was sentenced to undergo life imprisonment under section 302 IPC with a fine of rupees 10,000, in default, rigorous imprisonment for 1 year under section 30. He was also sentenced to undergo a rigorous imprisonment for a period of 7 years under section 201 IPC with a fine of rupees 10,000, in default, a rigorous imprisonment for 1 year. The sentences were to run concurrently. The prosecution case, in brief, is that an FIR dated 22/8/2004 was submitted by PW12. Prosecution witness number 12, bracket PW-12, right, Lord, who is the uncle of the deceased boy of how many years? Of 5 years, 5. The FIR is to the effect that on receiving the news that his nephew Chanakya Barwa had gone missing, an extensive search was made. Later, he came to know that at about 11 p.m., his brother-in-law, bracket the appellant, right, Lord, recovered the dead body of his nephew Chanakya Barwa from the septic tank located in the campus of the government quarters where he lived. The FIR also stated that, the PW12 in his FIR also stated that Binod Mrida, who stays in the house of the appellant as a domestic help, had stated that the appellant had committed the murder and that the appellant had also confessed to killing his son. In pursuant to the FIR dated FIR dated 30/04/22. DFU PS case number 116/2004 under section 302/201 IPC was registered. Next paragraph. After investigation of the case was completed, the IO, investigating officer, bracket IO, submitted a start sheet on finding a prima facie case under section 302/201 IPC against the appellant. Thereafter, the learned trial court framed charges under section 302/201 against the appellant. On 5/5/2018 and 16/9/22. The learned trial court thereafter examined 12 prosecution witnesses, and after examination of the appellant under section 313 CRPC, the learned trial court came to a finding that the appellant had been guilty in murdering his child and of having hidden the body. Full stop. Consequently, the learned, consequently, the learned trial court convicted the appellant under section 302/201 IPC and sentenced him as indicated in the earlier paragraph. Earlier paragraphs. Next paragraph. The learned counsel for the appellant submits that the appellant has been convicted solely on the basis of his statement made under section 164 CRPC. Without the magistrate having without the magistrate having followed all the requirements required prior to recording and a statement under section 164 CRPC. He submits that due to the confessional statement of the appellant having been recorded without following the mandatory requirements provided in section 164 CRPC. The defect in the confessional statement, recorded confessional statement of the appellant would be fatal to the admissibility of the said document, and accordingly, the same cannot be used as evidence against the appellant. Full stop. He submits that there is no evidence adduced by any of the prosecution witnesses against the appellant. Full stop. Though the statement made by PW1 in under section 161 CRPC shows that the appellant had slapped the boy and beat the boy on his chest and pushed him near the steps, due to which the boy got hurt and became senseless, and the fact that the appellant had picked up the dead body, had picked up the body of the boy, had picked up the boy and thrown him in the latrine tank, the same being a statement made to the police, it was not admissible as evidence. In any event, the said fact did not show that the appellant had any intention to kill his own son. Next paragraph. The learned counsel for the appellant submits that prior to recording the appellant's statement under section 164 CRPC, only 3 hours time had been given for reflection. Had been given to the appellant for reflection. He further submits that no certificate had been made by the judicial officer at the bottom of the confessional statement made by the appellant in terms of section 164 bracket 4 CRPC. He further submits that prior to recording the confessional statement of the appellant, it was the duty of the judicial officer to give an assurance to the appellant that he would not be sent to jail. He would not be sent to judicial custody. Judicial custody or no, not be sent to police custody, not judicial, police custody. Even if he did not give his statement, give his confession statement. Next one, the learned counsel submits that the evidence on record does not show that any case under section 302 or 304 has been made up. At best, the case would come under section 304A IPC. He accordingly prays that the impugned judgment should be set aside. It should be set aside. Next, Miss S. Jahan, the learner additional PP, on the other hand, submits. Yes. What is submit?
Confession can so basis of the conviction. Here comes I is I.
Submits that as conviction can be based on the sole on the basis of the confessional statement made by the appellant in terms of the judgment of the Supreme Court in the case of
I send the name. And then AI probably.
I have put it in my judgment also, I think.
Yes, AI probably was the assistant collector. This one I sent it, I've made it objective in paragraph 16 of that.
Yeah.
Isn't it?
No.
But what you can see is probably paragraph 16.
It will be here. I think.
Yes. Where is there?
I think they have turned the page and now you
Paragraph 16 and 5 lines over the top, but I
just a minute.
Trial.
Yes.
In a criminal trial, commission under the provision of Indian Penal Code, it is now well settled legal position that confession can form the sole basis for conviction.
That was in the customs case.
Yes,
That was
customs,
the custom.
customs case.
And then if it is retracted, now they have referred to 164. If it is retracted, it must first be tested whether confession is voluntary and truthful in culpating the accused in the commission of the crime. Confession is one of the species of admission dealt with under section 24 to 30 of the Evidence Act and 164 of the. 164 will also dealt with along with customs. So what lordship has to see is voluntariness. And now it is seen from the statement of record.
No, even if it is voluntary, even if we accept it to be voluntary, and it appears to be voluntary, okay, but the fact remains that his he does not inculpate himself to the extent that it is murder. It is only to the extent that, yes, he is the cause of the death. But it was not, he did not attempt to murder. I mean, it is not his intention to kill his son.
So the statement includes both inculpatory and exculpatory.
Yes.
Exculpatory that I have stated.
Yes.
Statement I did not give.
Yes, it was not his intention to kill. There's nothing where, so that motive part is not there.
If lordship can separate inculpatory and exculpatory. Inculpatory is that I have to simply hit him.
Hmm.
And exculpatory is that I simply hit him, inculpatory and he died.
Ah,
So-
anyway, right, whatever it is.
AI Pavuni.
K.I. Pavunni, Pavunny. K.I. Pavunni.
This statement.
K.I. Pavunni versus Assistant Collector, bracket HU, bracket close, comma, C. What is the,
I have not seen it.
no,
Citation, my lord, will find it
And this one I've given it from Madhukar, I can get it.
1997, 3 SCC 721,
1997,
3 SCC
3 SCC,
721.
721. Just let me check.
Lord, at paragraph 27 of the judgment.
Just a minute,
Paragraph 27 of the judgment.
just a minute, Mr. Counsel.
Okay, sorry.
No, why in such a hurry? Nineteen ninety-seven. What are the judgment? These pens are not working. 1997, 3 SCC.
721. Lord.
That's all, my submission is something like
That's all.
And that it was, the body was recovered as shown by.
First up, further, the body was recovered on being shown by the, on being recovered, on being taken out, no, on being shown by the appellant as to where the body lay.
May not be a problem. This is-
First up, she further submits that though she submits that it may not be a case of section 302 IPC on a careful perusal, appraisal of the evidence. First up, however, the case would come under section. It would come under section 304A or section 323 IPC. Ah. Anyway, 304A slash 323. Okay, you wanted 323, okay, 304A, you cut. 320. There was another aspect, just now you mentioned regarding the, just write one thing. The learned counsel for the petitioner, the appellant, further submits that the confessional statement of the petitioner, of the appellant, was retracted during his examination under section 313 CRPC. That. Okay.
And guideline probably can say that this is, so the strict application of the guidelines of the.
I would not say anything. Why should
No,
I?
my sub.
Okay, okay. Good stuff. Miss, page 137.
I was and magistrate first class on that day. I think it was- So that, that time, 2005, I think it was. Established.
Correct. Ms. El Jahan, the additional PP further submits that that in that during the year, the confessional statement of the appellant was recorded, that is in the year 2004. The no, justice was being delivered. Justice was being delivered by executive magistrates and not by judicial magistrates. Correct?
Something.
No, you see, judicial even not by judicial magistrate means by executive magistrate. I don't know. So what have I said? In the district of Diffu. First of as such, the strict guidelines laid down in section 164 CRPC was not required to be followed prior to recording of the confession statement of an accused. So long as the general guidelines, what? So long as what? Strict, follow, the CPC, what have I said? So long as, last part? Full. That's all. That's all. Okay, we have heard the learning, she according, we have heard the learning for the party. Okay, so, we'll say judgment, hearing concluded, judgment reserved. But it will be either 304A or 323. Period, undergone, probably. Or if not undergone, maybe another year or so.
The period undergone, my lord may also consider, and my lord, as of now, my lord, she has one daughter and their wife. But that aspect also be taken, and my lord, regarding the, my lord, lapses of that, whether judiciary was separated or not separated, the benefit should go to the then accused. My lord. Why this has not been complied on, why it should have been complied with? If at all the benefit has to go to the accused.
What benefit?
That, my lord, the judiciary was not in full swing at that moment, at that time. That is why the magistrate did not follow all the procedures.
No, you see earlier. Even in other states, not only here. The justice was being delivered on the principles of justice, equity, good conscience. It was not on the strict technical aspects laid down in the law. That was there. CRPC was only in principle of in a lot of these states.
The administration of justice.
Yes, there was administration of justice rules 1949, 1953. There's so many different. There was there. So as per those, this strict conformity with the technical aspect was not required. The general conformity, if it was there, then that was enough. Anyway,
All right.
oh, there's the matter. Yes, madam.
Lordship, the compliance affidavit. Lordship. The notice was served on 26/9/2023, Lordship, by Dusty. Annexure A, Lordship.
26/9 is what date? Last month.
Yes.
He's not coming. It's only for. Only for. Only for. Heard Miss
N Devi Lordship. I'm
N Devi
on
appearing
behalf
on
of-
behalf of Mr. R K D Chowdhury, learned DSGI. No one appears for the respondent. Even though notice has been served by way of dusty service upon the respondent in terms of the affidavit dated 6/10/2023, filed by the applicant. This is an application for condonation of 62 days in filing the appeal against the order dated 23/12/2020, passed by the learned special judge, NIA, Guwahati, granting bail to the respondent / accused in Miss case NIA number 46/2022, arising out of special NIA case number 3/2021 in connection with RC 04/2021 NIA GW, granting bail to the respondent. This is an order dated 16/6/2020. We have seen the grounds taken for the delay in filing this application.
Paragraph 13.
And on perusal of the grounds for the delay, we find that sufficient cause for the delay has been made. Accordingly, the delay of 32 days in filing the present appeal is condoned. Registry to register the appeal and leaves the same after review. IA is accordingly disposed.
Thank you. মানে আহা নাছিলে এনে মতলবটো সব কিছু
To enable him to engage a counsel for his choice, of his choice. Next, Mr. N.P. Goswami, the learned additional PP. Why do you object? The additional PP submits that the bill should be rejected, bill application should be rejected as the trial is at the argument stage. First of all, on considering the fact that the trial of the case is at the argument stage, this court does not find any ground to allow the petitioner to be released on bail. The application is accordingly rejected. Next.
I am obliged.
May it please your lordship. In this case, lordship, the case was registered against 376 and 4 of POXO Act, lordship. And after investigation, lordship, he was released on bail. But during trial, lordship, page 22, your lordship kindly see. On 22/2023, accused Ashraf Ali is present, lordship,
22, page 22.
page 22.
Yes.
lordship. Then on 17/3/2023, accused Ashraf Ali has filed his Hazira, but after calling him several times, he is found to be absent. So hence issued NBW against the accused Ashraf Ali. On next date, lordship, on 11/4, accused is absent today. NBW issued against the accused also not returned. And again on 10/5/2023, but the accused is absent today. Then lordship, on 23/8, he was arrested, page 24, lordship.
Yes,
On 23/8/2023, he was arrested, lordship, and thereafter he is inside the jail, lordship. And bail application was filed for releasing the accused, lordship, that was rejected.
what is the stage?
This lordship, after lordship, stage of the proceedings, lordship.
So evidence stage.
Lordship.
How many witnesses have been examined?
Lordship,
Huh?
only on trial stage, Lordship did not remain present for 3 days, and Lordship, it is reflected in page 29 itself.
No, but
Lordship,
you have no, you have not been present on,
On 3 dates, Lordship,
yes.
3 dates, Lordship. Earlier, he was granted bail by this court, Lordship. Lordship may release him. I am Lordship record that he will present on each and every date, Lordship.
But why were you absent?
Lordship, that reason was page 29, Lordship. Third paragraph, your Lordship will find Sri Y. Bepar Land Council appearing for the accused person submitted that the accused person is in jail hazard. Council also submitted that the accused is a poor man. He went to Kerala for livelihood under a contractor, Lordship. The contractor did not pay his money, for which the accused could not appear before the Honorable Court for several days, and the Honorable Court issued NBW against him. So Lordship, only on that ground. Now, Lordship, he is not moving to Kerala anymore, Lordship. If your Lordship grant
Why did you move to Kerala when you were in
for
bail?
livelihood, Lordship, in laborers normally went to Kerala for livelihood.
When a
Lordship.
heinous crime, no. Yes,
Since 23/8 he is inside, Lordship may consider, Lordship may grant his bail, Lordship, he will contest the trial, your Lordship.
no, but then no, you have not been appearing.
Then your Lordship may call the case diary, your Lordship, the scan copy of the case diary, your Lordship will find.
The records, everything is here. Oh, why should we need the CD?
No, Lordship, how many witnesses are there to be examined, Lordship may see on, after receiving the records, Lordship.
You have not been appearing while you were on bail. That
Only
is
on
good
3
enough.
dates, Lordship,
So-
only, and that too, Lordship, the petition was.
5979.
From 17/3 only on 3 dates, Lordship. The Lordship may impose any condition upon the petitioner, Lordship.
22, you are absent.
No.
17/3, you are absent. 11/4, you are absent. 2 months you are absent.
Lordship, in February, he is present, Lordship, page 22. Then March, he
No case,
went absent,
madam,
Lordship.
no case.
Lordship may call the case.
No, not required. When you have not been up.
Lordship can impose any condition.
Yes,
Paragraph 28, 30 and 31, Lordship.
yes. So was he called before the magistrate at the time of extension?
That is what I'm, he is now in his submission, he has made some, that the order is not, but he has not said anything order in this petition. He is only praying for bail.
Correct.
So, let him bail, for that purpose, I am praying for the.
Already I have annexed, Lordship, the order dated 18/8.
Page.
Page, Lordship, 24, Lordship.
Doesn't appear as if he was there in the court.
Yes.
Huh?
That part may not, maybe may not, doesn't appear, but I think I am not denying, whether he has appeared or not.
Then
Whether that order is in any way mandatory, that extension has been granted. Now, for releasing on of bail, then you must think that call for a record, see my whether how involvement is there. or
But then this order doesn't it clarify page 24?
Yes, but yes, 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 there are, but. Yes, but, because he is coming for bail.
Already ended the sober.
Not the. Come for my tenancy, he is not aware. He is not challenged the order in the process of.
Well, he doesn't want to challenge the order. He just says that
Because there is.
this
an
has been
order-
done, huh?
Because there is, rightly wrongly, but there is an order for extension, my lord.
Correct.
So, Lordship can grant bail, my lord,
Hmm.
but before that, my lord, Lordship may call for the city.
Let us call for the CD.
My name is not in the FIR, Lordship.
That is a different thing. FIR, you might not be there.
Yes, Lordship. I am an army man, Lordship, army person, Lordship.
Heard.
Because of as on today, was
J.
119
Learned counsel
days,
for the applicant who submits that the petitioner had been arrested in connection with
Cobra Gram PS.
Fakira Gram PS case number 43/2023 under section 384/506 IPC read with section 66 bracket F of IT Act, 2008 and section 10, 13, 16, 17 of UA bracket P Act. So he submits that the extension of the petitioner's detention by the impugn order dated 18/8/2023 had not been made by by the learned trial court by ensuring the presence of the a petitioner and without giving him an opportunity of being heard. Huh? So you just obtain information as to whether he was heard, whether he was there and present on that day.
Yes, sir.
Right. Mr. MP Goswami, additional PP shall obtain instructions as to whether the petitioner was present in the court on 18/8/2023 when the detention of the petitioner was ordered by the court. List the matter when?
Yeah, tomorrow.
This is a matter of Friday.
Published.
Item 6 and 7. The person is same, my lord. 7 he has been arrested and in 6 he has been shown arrested. So my lord, item 7, my lord, maybe taken.
Then what is the relevance of 6?
My lord, 6, my lord, he is shown arrest in another case. My lord,
There are two different cases.
2 different cases. So my lord, lordship may call for the CDA for the case. my lord.
Okay, right.
And
Item number 6, my lord, here by the wildlife council will appear because the wildlife case has been registered as by the OR number. In 7, I can appear. Yes, yes.
And what to do? Who is for the wildlife? In item 6,
my lord.
After something.
okay, item 6 after. Item 7, you right, heard Mr. A.R. Sigda, learned counsel for the applicant who submits that the petitioner should be released on bail in connection with case OR number PB, no, in connection with
PB oblique 4/2022.
with OR number PB/04 of 2023 under section 9/35 brackets 6 and 8. What is this? What act is this?
My lord, it is Wildlife Protection Act.
Wildlife Protection Act.
And this is in Tara 2, huh? What did he do? What did he do? What did you do?
My lord, my lord, rhino horn, my lord,
Oh,
has been procured collected from my house, my lord. That is the allegation. But that, according to petitioner, this is, my lord, they made up, my lord. It's not origin, my lord. It's
No,
made
no,
of
no.
some other materials,
okay. Rhino horn made from other materials.
other materials, my lord. Not
Made by
your-
whom? Made by whom?
My lord, some people, my lord, they are doing business, my lord, and he has also given a to keep it in the house as a show item, my lord. So, my lord, he is innocent, my lord. Unknowingly, he has kept it, my lord, in his,
Unknowingly has kept it.
my lord. And the fact is that, my lord, there was a prayer for conduct and test on the matter.
When were you arrested?
My lord, he arrested on, my lord, on 9, he has been arrested, my lord.
9th of?
9th of September.
Right, Mr. MP Goswami. Additional PP shall produce the CD. This is the matter.
My lord,
After,
my lord, before vacation, my lord, on the 18th
This
or
is the
19th.
this is the matter on 18.
Deep leverage.
May it please your lordship. Lordship 439 application. The petitioner before your lordship is a police officer of the rank of DSP. Lordship, allegations are multifold, my lord. FIR is from page number 12. So this person, along with his superiors and other colleagues, my lord, they've been implicated of torturing and extorting money from an accused person. So that is in a nutshell, my lord, long FIR. Possibly my learned friend would say that the case diary would be required, my lord.
Okay, right. Heard, Mr.
DK Boito, my lord.
Learned counsel for the petitioner who submits that the petitioner has been arrested in connection with CID PS case number 14/2023. He submits that the petitioner should be released on bail. He prays that the petition should be released. Mr. MP Goswami, additional PP is granted.
On 19th, my lord.
17. 17.
Shall produce the CD on 17. Release the matter on 17.
17. Deeply obliged, my lord.
May please the lordship, my lord. This is 439 application, my lord.
Under what section?
Section, my lord, here 448, 354B, 506 and section 8 of POXO, my lord. My lord, petitioner behind the bar as about till today, 33 days, my lord.
33 days.
33 days.
Oh, very long time.
Long time, my lord. Another, my lord, here there is a delay of filing FIR, my lord, about 23 days. There is a land boundary dispute between the informant's family and the present petitioner's family.
What to do? CD.
CTN, madam, then notice was to be-
Huh?
Notice also has to be sent to the police. Also,
So you'll have to send the notice to the OC.
so I was thinking, or, my lord,
You have to do it through the OC, then through OC or IO.
That's the process.
and, they can also, if they want, they can also, my lord,
No, they cannot. That is not the mandate of the order passed by this. Right, heard, Mr.
Islam.
M. Islam, learned counsel for the petitioner who submits that the petitioner was arrested in connection with Pathshala PS case number 58/2023 under section 448/354 bracket capital B/506 IPC, that with section 8 of the POXO Act. Also, he submits that the petitioner was arrested on 7/9/2023. And that there was a delay of how many days?
23 days.
23 days in filing the FIR.
Yes.
He also submits that the reason for the false case is that there is a boundary dispute
Yes.
between the family of the applicant, a petitioner, and the family of the victim girl.
Yes.
Next para, Mr. MP Goswami, additional PP shall produce the CD.
Before we get.
Actually, before that, right, issue no, shall produce the CD, full stop. And besides the above, the petitioner shall serve a scanned copy of the bail petition to the registry of this court, who shall in turn furnish the same to Mr. MP Goswami, additional PP. Full stop. Mr. MP Goswami shall thereafter send the same to the OC of the Pathshala PS, who shall serve a copy of the same to the respondent number 2. Who is the respondent number 2?
Informant, my lord.
Father, brother, what?
No, my lord. Victim's grandmother, my lord. Grandmothers of the victim. My lord.
So respondent number 2. What happened to the father, mother? Are they still alive?
Father is alive, but not.
Okay, respondent number 2. The Mr. MP Goswami shall thereafter submit a report with regard to the service on the respondent number 2. It is this matter. When?
18, madam.
On 18, wherein Mr. MP Goswami, addition PP shall produce the CD. Allah is good.
Item number 6.
Well, my friend is, I mean, well, it may be also fixed on the same date, madam. What was that? 18.
Okay, right. Mr. A.R. Sigdar prays for bail in connection with
My lord, it is Ullai
OR number PB/04 of 2023. It is the same case as 7.
My lord, I have annexed both the FIR, but in the earlier case, my lord, he was shown arrest in this case of the another case. armed
Mr.
act.
Counsel, you are asking for bail by 2 different petitions.
My lord.
How can it be? You
No, my
withdraw
lord,
one.
I have annexed both the FIR in both the FIR. My
So there are 2 different cases
My lord, both the case. My lord.
or the same case.
No, my
Show
lord.
me item 7.
My lord.
If the case is the same, if it's the same, then
No, my lord.
you
No, my
withdraw.
lord.
It's the same.
Item 6(2). Confuse police I will people like.
Yes, this is the same PB04
No, my
2020.
lord, there is another case, my lord. Lordship may kindly have a look at, I am also confused because this, which scale is for which one, my lord, I am also confused, my lord. Number is,
Well, I'll help you with your confusion. I'll dismiss one case.
my lord, no, my lord, the FIR is different.
Next,
Well, I have annexed both the, one FIR in.
Mr. Counsel, there is one case, 04/2023 in both.
Yes,
You
my lord.
cannot ask for bail.
No, my
with
lord, I have
regard to
not
the
asked
same
in
case.
that case. I have only annexed in that case because I was, while I was at detention in that
Okay,
case.
tell me the case number in this item 6. What is the
My
case
lord,
number?
so far my reading item number 6. Item number 6, my lord.
What is the case?
The FIR lordship will find at page 3, annex
I'm-
3.
hmm.
It's an arms act, madam. In this case, he has been shown arrest, my lord, while he is in arrest in another case, madam, PB case, madam. Annex 3, madam. So I am praying for bail in this case, my lord, under arms act, madam.
Okay, in item 6 is under the arms act. Huh? Oh, okay. Then you have made a mistake in your prayer.
My lord. No, my lord. Kindly have a look, my lord. Pair person is different, my lord.
Let us go to item 6 first. Since we're in item 6, let us see what is your prayer.
My lord, item 6. In that case, my lord, I am seeking bail in wildlife protection case. My lord. OR PB oblique 4 oblique of 2023 under section 9 oblique 35. 39. Meaningless. No. Duta bilik. One piece, please, sir. Okay. Let's see. More fully going to start.
He is asking for bail in item 6
My lord.
in the Panbari PS case.
Yes, my lord.
No, that is what I've got. You have mixed up. You have mixed up your case. 3603.
86.
3603. A prayer portion. Huh? No, just see this. I'll give you item 6. Huh? We'll see. Anyway, let them see. We'll ask them to withdraw everything then, file afresh. So it's a confusion on your part. So Mr. You'll be appearing in 360 in item 6, that means. Item 6. In the item 7, instead of MP Goswami, you put Mr. D. Gogoi. And then in item 6, you write, heard Mr. Yasigda, learned counsel for the petitioner who pays for bail in connection with Panbari PS case number 54/2023 under section 25 bracket 1 dash capital A of the Arms Act. Mr. MP Goswami, addition PP shall produce the CD on where's which
My
date?
lord, on same day, 18, my lord.
18.
18 October. Leave lovely. And then. May I please, your lordship? May I please, your lordship? My lord,
Yes.
Pokso matter, my lord, but my lord,
Catch it.
and my lord, scan copy maybe call for my lord and note.
Has added section 370 bracket 1 bracket 4 slash 370 dash capital A bracket 1 slash 376 bracket 3 IPC. Read with section 6 of the POCSO Act. He prays for bail on the ground that the petitioner has been in jail for 56 days. And as the preliminary investigation of the case is over, further custodial detention of the petitioner is not necessary. Mr. MP Goswami, additional PP on the other hand submits that the victim is 13 years old. And the investigation of the case is not yet over. As the case is of a very serious nature. And keeping in mind that the petitioner is a police constable, the bail should be rejected. Mr. Counsel, your name is not in the list.
I'm Mr. T. Dury, Your Lordship.
Mr. J. Raba appearing on behalf of Mr. T. Dury, huh?
The city may be called for Your Lordship.
On considering the above, this is the matter after the vacation. Mr. MP, MP Goswami shall produce the CD on the next day. On 7th, huh? 7/11.
Maybe it is a Lordship. Lordship in this case, Lordship, the long affair, Lordship. The case 8, and it's in the starting, case 8, Lordship is affair. It started with finally coming to this 13. If initially, Lordship, a complaint has been filed before the Chief Minister, Lordship, of Assam. Allegations, Lordship, all the allegations against the police person, SP, additional SP, DSP, OC, in search of outpost, ASI, Lordship, everything, all the police person, Lordship. Allegations, Lordship, illegal search operation was done, Lordship, in the house of victim, and he was tortured. Lordships demanded extortions, Lordship, and threatened to kill his life, Lordship. Lordship, in his rare portions, Lordship, in his complaint,
What is the charge against you?
yes, Lordship, the search, Lordship 307, Lordship 379, 387, Lordship, and along with the sections 98.
Okay, right, heard, Mr.
I have, Lordship.
I have learned counsel for the petitioner who submits that the petitioner was arrested on
29, Lordship.
2/9/23 in connection with CIDPS case number 14/2023. Good, sir. He accordingly pleads for bail. This is the matter on when 7/11. Come on.
Lordship, item number 8, Lordship, the same affair, Lordship. That matter is 6/17.
Okay, this is the matter on 17. Come on, which date? Mr. MP Goswami, additional PP shall produce the CD.
Highly obliged.
In this case, the petitioner is undergoing trial in connection with NDPS case number 112/22 before the Nagaon Additional District Judge. And he was arrested, his petition was arrested on 27/2/2022. And still they are in jail. So by this time, Your Lordship, they have spent 1 year, 7 months more. Until date only 5 witnesses have been examined by the trial court. So now it appears that the conclusion of the trial in the near future is not possible. Moreover, Your Honor, from the evidence so far adduced by the prosecution, it appears that they have totally failed to prove the manner in which the seizure was done. And seizure witnesses also, they have categorically said from the evidence, it appears that their involvement of the petitioners cannot be confirmed. In fact, we have annexed the prosecution witness deposition also. And out of the 5, 1 witness has been declared hostile also. And in the meantime, we filed a bail application before the trial court. And the learned trial court kept pending that bail application for 5 months, and ultimately the petition was rejected. For 5 months, this petition was kept pending on bail application. So considering the detention and there is no chance for hampering or tampering the evidence as indicated in the bail order, the rejection order. So under these circumstances, I pray before Lordship that this petitioner
We'll have to issue notice. Scan copy of what? Your charge sheet, you produce the charge sheet, why have you
I
not
have produced,
produced?
I have already produced, Your Lordship. Charge sheet and deposition also I have produced.
So what remains? That you get the information. You have got to do some homework for yourself also. Okay, you get the, how much? Let us see the charge sheet, how many witnesses are there?
Your Lordship, may kindly see the charge sheet. Your Lordship will find that space. Annexure 4 is the charge.
Annexure 4,
4, page 27. Witnesses, Your Lordship will find 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15. Only 5 witnesses have been examined so far. In last 1 and 6 months.
right. Heard, Mr.
And Sharma.
Hey, Sharma, learned counsel for the petitioners who submits that the petitioners have been arrested in connection with special NDPS case number 112 bracket N/2022 arising out of Samaguri PS case number 74/22 under section 22C NDPS Act. The petitioners counsel submits that out of the 15 prosecution witnesses cited in the charge sheet, only 5 witnesses have been examined. It submits that the evidence adduced does not connect the petitioners with the crime. But then the other witnesses available. There are 15, 5 out of 10 means 15 are still left.
But Your Lordship, in the NDPS case, the seizure procedure is a key procedure, Your Lordship. If seizure is not proved as per section 42, 52 and 57 of the NDPS Act, then the chances is very remote, Your Lordship. So the seizure witness, there are 3 seizure witness.
It doesn't mean, what do you mean? The Caesar witness, there'll be the police Caesar witness, the police will be there also.
Yes,
It doesn't, it's not required that only the independent Caesar witness should be there.
But there are named, there are 3 seizure witnesses, and if you just look at the their version, deposition, Your Lordship will find that there is no chance for at least.
Anyway, we have to give notice to them. Right, issue notice to the, no, Mr. MP Goswami accepts notice on behalf of the state. List the matter on
Thursday, madam.
Huh?
Thursday, madam. 10th of November.
This is a matter on 10/11.
Scan copy, Lordship, may I?
Scan copy of what? You have the series there, the chart sheet is there, so what is required?
14.
DPS. Lordship, the case is under section 21 C and 29 NDPS, Lordship.
No, let us see how many witnesses examined.
Six, it is.
6 out of,
No examination witness. This is a appearance in this case.
Huh?
Appearance in this case.
appearance stage.
The petition is behind about 323 days, behind about. Arrested on 20/11/2023.
Charge sheet filed or not?
Partially fine.
Then charges framed or not?
No family.
Charges not framed. Huh? Have you approached the
Yeah, what's it? His number
page number?
27. No, order is order.
Hussein Hamid is absconding. But then the trial should start against the remaining accused. Just because one person, supposing he absconds for the next 5 years, then what will you do? Huh? You cannot keep him pending. You try in the trial that person can be convicted in absentia also. Hmm.
Yeah, absolutely.
But what is the ground for allowing you to be released on bail?
The lordship, the petition was behind about 323 days.
That is no ground, Mr. Counsel. 37 is there.
The another is
303 days.
323 days.
Then that is no ground.
One is absent, the case is delay, not further proceeding, that person only, the which is Hussein Ali abscond.
Huh? No. Right, heard, Mr. What's your name?
Yes, Ali.
Heard, Mr. S. Ali, learned counsel for the petitioner who submits that the petitioner has been arrested in connection with how many grams? 1 kg.
1 kg
In connection with 1 kg of heroin. Heroin?
heroin. Lordship,
In NDPS case number 60/2023 under section 21C/29 NDPS Act. The petitioner was arrested on
2011/2022.
2011-22. 2011-22. 2011-22.
November.
And though charge sheet has been filed, charges have not been framed till date.
Lordship, another same affair or another petitioner fixed on 7/11,
He submits,
2479 DNO.
he submits that the petitioner should be released on bail as he has been in jail for 303 days. That's all. That's the only ground. No other ground.
These are, only the charge sheet has been filed. No, there is no hamper and temper the evidence of the case. And the petition shall appear, regularly appear before this below trial court.
He submits that if bail is granted, the petitioner shall not hamper with the trial or tamper with any evidence. He shall also not try to influence any of the witnesses. Next, Mr. MP Goswami. Additional PP appears for the state. On considering the provisions of section 37 of the NDPS Act, it is clear that bail can be granted where the court is satisfied that there are reasonable grounds for believing that the accused person is not guilty of the offense and not likely to commit the same offense while on bail. Full stop. In the present case, the petitioner has not been able to show that he was not the petitioner has not, in the present case, the petitioner has not been able to show that there are reasonable grounds for believing that he is not guilty of the offense. Full stop. As such, this court is not inclined to grant bail at this stage. The petition is accordingly rejected. Next.
My lord, kindly this matter may be passed over, my lord. After vacation, any days, my lord.
What is the matter about
I have no any briefs, my lord. I have been studying.
20B2C?
Yes, my lord.
How much? How many grams?
I have no any idea, my lord.
You have no idea. Well, if you have no idea, then
The passed over, my lord.
no. 21 to 20. How much is this? How many grams? Kgs?
575 kg ganja.
Has charge sheet been filed?
That's it,
Satisfied.
that's it, fine.
My lord, kindly, my lord.
No.
YS Manan has instructed me, my lord.
Huh?
YS Manan is the senior, my lord. He instructed me, my lord. That's why, my lord. Kindly pass over, my lord. Move submission, my lord. As per senior instruction on I am appearing, my lord. So,
Incorrect. This is an application for bail regarding the seizure of 575 kgs of ganja. The petitioner has been arrested on 26 to 2023. No. 21 to 2023. 21 to 2020. And charge sheet has been filed in the present case. On the prayer for adjournment made on behalf of Mr. Y.S. Manan, this is matter after the vacation.
yeah, that may be fixed. my lord.
List the matter on when?
Okay. 6.
Huh?
6:11.
6/11.
Available, my lord.
25. How many matters do we have?
May I please your lordship? My lord, in this case, lordship, I was arrested on 21/11/2022, my lord. Already 318 days, my lord, I was behind the bar, my lord. In this case, my lord, after search sheet filed by the search sheet by the 6 witnesses, 5 witnesses were already examined, my lord. There is no chance of absconding or tempering investigation, my lord.
How many kgs?
My lord,
1.89 kg.
31.
my lord, there is 6 days.
31 point?
89 kg.
My lord, 6 bundles of.
Arrested on 21/11, huh?
11, my lord, 11 months already, my lord, suspected ganja, my lord. My lord,
So the charge sheet is there.
yes, my lord,
Charge sheet says it is ganja or it is suspected ganja. What does the FSL report say?
suspect,
Positive.
not sure, my lord, and my lord, already, my lord, 5 witnesses were examined, my lord. There is none to his house, my lord, not a single person was there, my lord, to look after his old aged parents, my lord. Already, my lord, 11 months.
How
my lord.
many accused persons?
Only one, my lord. Only,
Okay, because on a tip of
Madam, this is a commercial quantity. Commercial quantity, the bail can be granted only under section 37. Now you have got to see whether 37, you come under the provisions of 37 too. That's all.
My lord, 20, the search sheet was from 20B to C, my lord.
Huh?
Again, my lord.
20B2C is commercial quantity,
Yes,
madam.
my lord,
Then-
yes.
Then
6 kg. My
You
lord,
have
as
got-
I heard, FIR also PW1, SP with Replica Pulibor PS, my lord. He filed a Azahar and suspected ganja. She was written as suspected ganja, my lord. My lord, he will appear any condition implied upon him, my lord. He
Madam,
will
I am
appear.
I am bound by the law. I am, have you read 37 of the Indian PS Act? Have you read section 37?
It happened to him.
37 1B2.
My lord, there is no sense of absconding or committing any other offense because this is his first offense. Nowhere stated that he is a habitual offender, my lord. He is only 32 years old, my lord, and old parents, my lord. There is none to look after his old aged parents. My lord. 11 months he is sufficient punishment, my lord. Again, if he is guilty, then my lord, again he will appear and
Correct. Heard Miss
kindly, my lord, may consider this
P.P.
bail
Botolo,
application.
learned counsel for the.
And I am legally
Petitioner.
counsel, my lord, as legally counsel, I am appearing.
So it doesn't matter to you whether you succeed or not. Okay, right. Heard Miss P.P. Botolo, learned and legal aid counsel for the petitioner, who submits that the petitioner was arrested in connection with the seizure of 31.894 kgs of ganja in Pulibor, PULI, PS case number 216/22 under section 20B2C MDPS Act. Next para. The petitioner's counsel submits that charge sheet has been filed.
Yes, my lord.
And
For examine,
and 5 witnesses out of
6.
6 witnesses have been examined.
My lord, kindly
Full stop.
consider this. My lord, already 18 days, my lord.
So there's a
11 months, my lord.
full stop. She submits that as the petitioner has been in jail since 21/11/22. The petitioner should be released on bail. Full stop. Mr. MP Goswami, the learned additional PP, objects to the bill petition on the ground that there is nothing to show that the petitioner is not guilty of the offense. Full stop. I have heard the learned counsels for the parties. Full stop. In view of the fact that the trial before the learned trial court is at the
Any conditions, my lord.
is at the stage of at the end stage, and keeping in view section 37 of the NDPS Act, which provides that the court should be satisfied that there are reasonable grounds for believing that the accused is not guilty of the offense committed. This court finds that there has been nothing to show that there has been nothing to show on the part of the petitioner that he is not guilty of the offense. So accordingly, accordingly, in view of the above, this court does not find any ground to allow the petition. The appeal is petition is accordingly rejected. Next. This is the last one.
Highly obliged.
Here, madam, item 22 and 28 are for the same case. 22 is adjourned.
22 is done.
Adjourned.
Yes. What?
No, I was not aware that item 22 is connected with this case. Lord.
How much kg?
Here 40 kg not recovered from her possession. Lord. It was recovered from other accused persons and only on the basis of co-accused statement, the prison lady is behind bar. And no witnesses examined till date, although charge sheet is filed. And in this connection, Lordship, I have coordinate bench judgment and honorable appellate court judgment, Lordship, to support my case.
Which says
To say, Lordship, that the co-accused statement is not
it's
sufficient.
not
to
admissible.
fulfill. Then
How about the other cases again? You should have a bearing.
probably his case is different because my case is that other two accused persons, from them it is recovered. From me, it is not recovered. Only they said that I am involved. So.
What is
they-
that
they are-
judgment? That is
Just I'm touching.
40 kgs,
40 kg.
40.30. How many judgments, Kapil? On one point only.
Different courts and on one affects. The last one, Juma sir, that will cover my case entirely.
No, let us see this first. Supreme Court.
Para 11. Last. In the absence of any psychotropic substance found in the conscious possession of A4, we are of the opinion that mere reliance on the statement made by A1 to A3 under section 67 of NDPS Act is too tenuous a ground to sustain the impugn order. This is all the more so when when such a reliance runs contrary to the ruling of Tufanti. And next case, Lordship, High Court judgment Nure Jaman Islam, he was granted bail and that order was challenged in Supreme Court and Supreme Court dismissed that case, Lordship.
In
Nure Jaman Islam, DA number
Nure Jam-
1464. That was challenged in Supreme Court.
Zaman Islam. Oh, yes.
Here also that section 37 is elaborately discussed from page para 4 onwards, Lordship. 37 is discussed and Honorable Supreme Court judgment is also there. And final finding, your Lordship will find paragraph 11 here also. Keeping in view. Yeah. Keeping in view the above principle, let me consider the prayer for bail of the petitioner on the basis of materials brought on record. From Central Intelligence Officer received the secret information on 25/2/2019 that one Moghreb Ali along with his co-accomplice Ziaur Rahman and Abdul Mutleb Mir were going to transport huge quantity of Recofax codeine-based cough syrup by his own vehicle bearing registration number so from Guwahati to Dhubri. Pursuing the said information, the NCB team intercepted the above mentioned vehicle and found accused Moghreb Ali, Ziaur Rahman, Abdul Mutleb Mir in the vehicle and seized 600 bottles of codeine-based cough syrup, 1200 bottles of codeine-based cough syrup from the above three accused persons. Evidently, no contraband article was seized from the possession of the present petitioner, nor he was present at the place of occurrence. According to the learned standing counsel for the NCB, petitioner was arrested on the basis of the statement the co-accused Moghreb, who stated in his statement purportedly recorded under section 67 of the NDPS Act that he would sell 68 grams of methamphetamine tablets to the present petitioner. The petitioner in his statement purportedly recorded under section 67 of the NDPS Act denied such averment of the co-accused Moghreb. Therefore, materials on record clearly show that no contraband involved in this case was recovered or seized from the possession of the present petitioner. Inasmuch as admittedly all the contraband, cough syrup and methamphetamine tablets were seized from the possession of the other co-accused as mentioned above. Except the purported statement of the co-accused Moghreb Ali recorded under section 67 of NDPS Act, he was supposed to sell the 68 grams of methamphetamine tablet to the present petitioner, which was denied by him. No other material has been brought on record to connect the present petitioner with the recovery of contraband. or the offense of the present case. In view of the above material, it is difficult to hold that the trial against the petitioner may in all probability culminate in conviction. Therefore, I am satisfied that there is no reasonable ground to believe that petitioner may be ultimately held liable for the offense in this case.
Yes,
I have given another judgment, another order of Juma Saha, DA number 2433 of 2023.
yes,
This actually covers my case also. Lordship may condition say, it is in second page, Lordship. Scan copy of case record is placed before this court. The case relates to recovery and seizure of 104 kg of ganja from train Rajdhani Express. It is noticed that accused petitioner has been in jail custody since 1/11/2022, that is for 277 days. The seizure list shows that one blue color Vivo mobile handset along with SIM card and one electronic reservation sheet bearing number so-and-so in the name of accused petitioner was seized from her possession. Perusal of the case record shows that learned trial court frames charges under section so-and-so NDPS Act against the accused petitioner and 3 others by order dated 8/6/2023. Thereafter, no PWD is examined till date, same as in my case. Keeping in consideration that no contraband item were recovered and seized from the exclusive possession of the accused petitioner, who is a lady, while traveling in the train as passenger, this court prima facie no reasonable grounds to believe that she is guilty of the offense subject, however, to final outcome in trial, and therefore she can be released on bail subject to condition. Here also in my case, she is a lady lordship, and nothing was recovered from her possession. And regarding that,
Though probably she is the kingpin. Probably she is the kingpin, but then no, we have to go by the evidence.
You could find the entire with the house is not just but it's considered position. 30 position, so it's under. Under. You know, they could see the entire house is either because those 2 persons were there for delivering the item to the lady. When those 2 persons were arrested, they after that were late by the he was arrested.
We'll hear this together with this other item, otherwise
They are acting not.
it's slightly right. Right. As this matter is connected with bill application number 2093/2023. This matter on 1710. Though he appears to have some point.
Yes, yes. That's also in my.
Against him.
Yeah.
Show me. One.
One matter that is regarding state is not in positive matter. There is matter where the constructive position is explained, that is one time.
I'm on last case.
And also there is a matter where at the time of bail matter, one thing case has been discussed, but in the coexist regarding the coexistence matter, that is part of the stages at the time of bail matter, the section matter. Taken under section 67 of the NDPS Act, that can be taken into account at the time of bail.
No, that aspect is clarified by the Honorable Apex Court that 67 or 161 statement that can be taken into consideration if it is anticipatory bail. If it is regular bail, then it cannot be taken into consideration. That is a clear-cut point on this. Our High Court judgment was there. That was challenged in Supreme Court, and Supreme Court clarified that aspect. In 438, it can that 167 67 statement is relevant, but when it is 439, it is not relevant. Yes, specifically said. I can place that judgment.
What is that judgment?
That I have not today. I have not brought, but I can place.
Anyway. Yes, sure. Tell me, I don't know.
Nothing.
Because I'm in a learning process.
We are also learning.
Huh? Okay.